Hi, Assalamualaikum. My name is Nur Amira binti Amiruddin.
Hey, Assalamualaikum. My name is Syaira Tunisa.
Hi, my name is Muhammad Nafi Farhan.
Hi, my name is Nazira Nafisa.
Hi, my name is Muhammad Shukri Ali bin Sidi.
First question is which the reference of Employment Act 1955 identify the condition under which Normala is allowed to commence her maternity leave before her expected date of confinement. Okay, first, according to the Section 37, Clause 1, Clause A of Employment Act 1955, a female employee such as Normala is entitled for a maternity leave for an eligible period in respect of each confinement. Next, according to the Section 37, Clause 1 and Clause B of Employment Act, a pregnant woman such as Normala again is not allowed to take maternity leave 30 days earlier or 1 month earlier before her confinement date. However, she is allowed to take the maternity leave if only she get approval from the medical officer or any medical practitioner appointed by her employer that certify her pregnancy state can result in unsatisfactory in her duties. So, she can apply the maternity leave anytime during the period of 40 days or 2 weeks before her confinement date. Plus, Section 37 Clause 1 Clause BB of Employment Act state that if the female employees take leave earlier than 30 days, the leave shall not entitled as a maternity leave, but rather than unpaid leave or medical leave. So, her action to take leave earlier than 30 days could result to the disqualification of the maternity allowance. So, to be related with the Normala situation, the doctor who is a medical officer has certified Normala pregnancy state and advised her to take the bed rest for 3 days. So, based on this, we can see that her unwell feeling can affect her work performance and indirectly can result to unsatisfied outcome in her duties. Plus, the maternity leave she requests for is 1 week earlier before her date of confinement and not 30 days earlier. So, to be concluded, her employer should allow her to take the maternity leave as she has successfully fulfilled the Section 37 Clause 1 Clause B of the Employment Act.
Next question, explain the maternity protection given to women under the Employment Act 1955. There are several maternity protection for female employees in the Employment Act 1955, but in this video we're gonna discuss some of them. First, Section 37 of Employment Act 1955 provides that a female employee is entitled to maternity leave for any eligible period for each confinement, as well as entitlement to maternity allowance. According to this section, the duration of maternity leave must be not less than 60 days for each confinement. However, maternity leave shall not begin earlier than 30 days from the confinement period as stated in the Section 40, unless the employee is certified unfit to perform her duties by any medical officer or medical practitioner. Therefore, if the employee is unfit to perform her duties, she may begin her maternity leave at any time within the 14 days before her confinement period as advised by the medical officer. In addition, Section 37 provides that a female employee is entitled for maternity allowance for the eligible period from her employer if she had been employed by the employer 4 months before her confinement.
Next, under Section 37, Clause 4, it indicates that any employer will terminate the service of female employee during the period in which she is entitled to the maternity leave. It will be committed as an offence. It provided that of the purpose of this section, such termination shall not include termination on the ground of closure of the employer business. Next, under Section 38 of Employment Act 1955, it will be referred to the payment of the maternity allowance. It stated that the maternity allowance referred to in Section 37 Clause 2 and occurring in each salary period under the contract of service of the female employee shall be in the same manner as if such allowance were wages earned during the such wage period as provided in Section 19. Next, under Section 40, which refer to the loss of maternity allowance for failure to notify employer. Under Section 40, Clause 1, it stated that a female employee who is about to leave her employment and who knows or has reason to believe that she will be confined within 4 months from the date upon which she leave job before leaving her employment, notify her employer of her pregnancy, and she failed to do so, she shall not be entitled to receive any maternity allowance from such employer. Apart from that, under Section 40, Clause 2 of Employment Act 1955, it stated that a female employee shall, within a period of 60 days immediately preceding her expected confinement, notify her employer of it and the date from which she intends to commence her maternity leave, and if she commences such leave without notifying her employer, the payment of maternity allowance to her may be suspended, and notwithstanding Section 38 until such notice is given to her employer. Therefore, it means that if female employee did not tell her employer about her reason, such as she was pregnant, and just take the leave without the permission of the employer, she will not deserve the maternity allowance. Last but not least, under Section 42, which refers to the restriction on dismissal of female employee after eligible period. Under Section 42, Clause 1, it indicates that where a female employee remains absent from her work after the expiration of the eligible period as a result of illness certified by the registered medical practitioner to arise out of her pregnancy and confinement, and to render her unfit for her work, it shall be an offence until her absence exceed the period of 90 days after the expiration of the eligible period for her employer to terminate her service or give her notice of termination of service.
With reference of Employment Act 1955, discuss whether Normala employer has the right to terminate her service. The first argument, the employer is not entitled to terminate Normala based on subsection 42 clause 1. A female employee shall not be terminated her service if she absent from the work after the expiration of the period of pregnancy and confinement certificate, and employer are prohibited from terminating the employee within a period of 90 days of the employee's absence. Besides that, any employer that goes beyond this act will be fined according to the section 99A. In this case, Normala was terminated by her employer within 90 days after the expiration of the maternity leave. Referring to section 42 clause 1, a woman cannot be terminated from her service within 19 days after expiration maternity leave. In addition, the decision of dismissal by Normala employers was void and can be challenged in the basis of unfair dismissal. An employer may be fined for the offences. The second argument, the employer is entitled to terminate Normala. The argument of the subsection 12 clause 4, the notice of the termination can be given at any time and must be written, which must state the period of the notice. Under subsection 13 clause 2, termination may be made without notice. In this case, Normala was terminated through a letter of the termination from the employer. Referring to the subsection 12 clause 4, 13 clause 2, Normala's termination is legal, and Normala and her husband cannot claim unfair dismissal.
Assalamualaikum. Now I will proceed to the last question, which is by referring to case study above, identify the social security benefit available for Normala. Benefit that available for Normala is maternity benefit. Under maternity benefit, Normala will get maternity leave, early maternity leave and maternity allowance. Normala will get maternity leave according to section 37 clause 1 clause A under Employment Act 1955. Every female employee has the right to get maternity leave for duration of not less than 60 days. According to Normala case, Normala pregnant who working as an production operator in electronic company. According to the Act, Normala was entitled to get 60 days of maternity leave. Next, early maternity leave. Under section 37 clause 1 clause B, maternity leave may not begin sooner than 30 days before a female employee's due date or later the day after her due dates. By referring the case, before delivery, Normala fell unwell due to her pregnancy. The doctor ordered her to rest. As a result, Normala had to take leave before delivery. Therefore, Normala have the right to take early maternity leave. And for the last, maternity allowance. Section 37, Clause 2, Clause A, a female employee shall be entitled to receive maternity allowance and accumulating each wage period under the female employee contract of service shall be paid in the same manner if earning earned during the wage period. According to the Normala case, Normala had to take maternity leave due to her confinement period and Normala was unable to work. Under the Act, Normala must be paid an allowance by her employer at the normal rate of pay for 1 day.